All right, so good afternoon. Welcome, and thank you for joining us for the final installment of our IP Summer School series. Such a bittersweet day to see it come to an end. I'm Haley Cook, Marketing Coordinator of Events here at Ward& Smith, and I will be your moderator this afternoon. If you have any issues with video or sound quality during the presentation, please reach out via the Zoom chat feature, and I'll try and troubleshoot with you. This webinar is being recorded, and I will send it out to you probably tomorrow morning with the recording and the slide deck. One thing I wanted to show you was how you can locate our previous webinars via our website. So you can share with your friends, family, colleagues in case they missed it. So once again, going back, we are at www.wardendsmith.com. You will go to webinars. Right now, it's right here, but what you're gonna, once the series concludes, it will move into past webinars and previous webinars, and it'll live right here. Right now, you can view it right here, and you can see our other three series, or other three right here, but it'll move. So please use that as a resource. Our speakers are happy to take questions during this webinar. I think it's going to be very casual, conversational. So please utilize the chat and Q&A feature in Zoom, and we will address them. So today we've got two great litigators from, of course, Ward& Smith with us, virtually with us. First is Joe Scouten. He's based in our Raleigh office and focuses on intellectual property disputes, patents, trademarks, copyrights, and trade secrets. The next is Peyton Bullard, based in our Wilmington office, handles trust and estates disputes and complex commercial litigation. Together, they'll be walking us through IP litigation, protecting your brand at home and abroad. So let's get into it. Joe, I'm going to virtually toss it over to you.
Thank you so much, Haley, and thank you for the introduction. And I promise that we will try very hard to make sure that the best IP summer school session was saved for last. Um, so just a little bit by way of background, I've been practicing about 22 years now. Have been doing IP since the start, all kinds of IP, and Peyton and I have been working together on these types of matters since basically the start of her practice as well. And we'll try to be very pragmatic in the information that we provide today. And we can look at the next slide has a little bit of a kind of setting the standard for what we're going to do today. So big picture, the IP enforcement process. And the thing that we'll talk about here today and hopefully help you with, and this is on the next slide, Haley, um, is that having IP rights and enforcing those rights are two different things. Uh, and I think we'll start by talking about two things that everybody can agree on and everybody understands, at least in the abstract. Having intellectual property is critically important to almost any successful business. And I just think about, in the time that I've been practicing, just in a given year, the varied types of intellectual property that I deal with. In one year, I'm working in a case involving packaging for red meat. And in the same year, I'm working on a case involving an alloy that goes into jet engine fuselages. In one year, I'm working on a case that involves a cardiovascular drug-eluting stent. And in that same year, I'll be working on a case that involves products used in the outdoors for camping or visiting the beach. So it's really IP is critical to almost every successful business. And the best part of what we do is we get to see how businesses develop their IP, how they begin to work through things, solve problems that the market is facing, develop a brand that the market can trust, and then we see how that, has benefit to them over time. And where we come in is where those rights are potentially being taken advantage of by latecomers to the market or somebody who wants to take what belongs to the business that worked so hard to develop those rights. And so if you have those rights, you have to be able to enforce them to keep them important as effectively. And that comes to the second point I think we can all agree on, or that most people have a sense of in the abstract, is that enforcing intellectual property rights is expensive, often very expensive. I was just looking at some data in preparation for this, and the estimates are, and it's of course hard to know this with certainty, but the estimates are that on the low end, a patent infringement case costs $700,000 approximately in legal fees to get through trial. On the high end, that can go up to $4 million. Trademark cases, a little bit less expensive, but on the low end, maybe $400,000, and on the high end, $2.4 million. So those are the costs to go to trial. Of course, most cases in the civil realm do not go to trial. They settle at some point before trial. So it's important so that you're able to position your case as strong as it can possibly be so that you can take advantage of your IP rights. You can enforce them in the most efficient manner and in a manner that hopefully limits the costs that are incurred by the business. So the goal here today is for us to provide you with some tools so that you can ask the right questions right off the bat when an IP issue surfaces, so that you'll be able to be positioned to enforce these critical rights when the need arises and to do so promptly. And the way we'll work through our program here today is I'll start by talking about some high-level strategic considerations that are critical to the initial positioning and the initial response uh, of a potential IP matter. And then Peyton will talk a little bit more about cost and work through the specific types of IP like patent, trademark, and trade secret, and how you kind of build those cases individually. So with that, let's start by looking at one of the first issues that comes up in an IP enforcement situation. And the first issue that often confronts a business when they discover an IP problem, somebody taking advantage of their IP wrongfully, is what's the first step? And there are there are, of course, multiple things you can do, but the two most common options and the two most frequently utilized options are one, to send a cease and desist letter as a hopefully a mechanism of avoiding a lawsuit, or to go straight to filing a lawsuit. And a cease and desist letter, of course, is one that demands the recipient stop infringing or misappropriating activity. It might ask for some information about sales so that you can assess damages. And it is an effort to enforce your rights between the parties without going to court first. So the question becomes, should you send one of these before filing or not? Now, if a cease and desist letter is sent and it doesn't work, then you proceed to court. But sometimes it's better to send one cease and desist letter first, and sometimes you might want to go straight to court. So how do you kind of evaluate that decision. And I think the best way to evaluate it is by looking at the advantages and disadvantages of sending a cease and desist letter. So the first advantage is probably the most obvious, and that the cease and desist letter is a less expensive way to resolve a dispute potentially without litigation. It costs less in legal fees to prepare and send a cease and desist letter than it does to prepare and litigate a complaint. And in an ideal world, the opposing party receives your cease and desist letter and says, "Oh my gosh, I did not know you had that patent," or "I did not know the marketplace was confused by me branding my product in this way," and says, "I will stop, and I will do everything I can to make this right." That's an ideal situation for send and an ideal outcome when you send a cease and desist letter. And of course, that happens. Maybe not frequently, maybe 5% of the time, but given the cost of litigation, it can be very well worth it if a cease and desist letter is able to resolve the problem without resorting to litigation. Another advantage of a cease and desist letter is it establishes a record of notice. And the record of notice can be important in a couple of different ways. With respect to patent infringement litigation in particular, there are certain theories of infringement, certain theories of indirect infringement, where it is very helpful, if not necessary, to allege in a complaint, to allege at the beginning of a lawsuit that the opposing party had knowledge of your patent rights and the potential infringement prior to the initiation of a litigation. So sending that letter, particularly in a patent infringement context, can open up potential the indirect infringement theories that might not be available if the other party does not have pre-suit notice of the patent. Uh, Another advantage in terms of establishing that record of notice is most IP claims, uh, patent infringement claims, trademark infringement claims, trade secret claims, involve or offer the opportunity for some type of elevated damages in the event of willfulness. And showing willful infringement can not only improve your odds of winning before the jury, can improve your odds of winning before the court, but it also potentially can increase the odds of getting a enhanced damages award. So it is helpful in many cases to be able to come to the court and say that, "Hey, I raised this issue before filing suit, and the opposing party told me to go pound sand. So I had no other option but to come to court." And their response to this letter shows that they are not only violating my intellectual property rights, but they are doing so in a fully willful matter. So that's one of the other advantages of sending a cease and desist letter. The last and probably, I think, most unique advantage of sending a cease and desist letter, and one that's not often talked about as this decision is made, is that you can obtain valuable information about the other party's defenses prior to filing a lawsuit. So, for example, in a patent infringement case, if you send a cease and desist letter, and the other party responds and says, I hear you, but I don't believe we infringe your patent because my product works like this, not like that. Or I don't believe we infringe your product or your patent because your patent's invalid because of this particular prior art. Uh, you can then be well prepared to address that in your complaint. Um, if you're able to address it, if they've got a point and you're concerned about it, You can even potentially go to the patent office and get additional patent protection that covers the arguments or covers the defenses that they are raising in the in the response to the cease and desist letter. They might say, "Hey, we're going to change our product in 6 months," and then you have a different decision. Maybe it's not worth it to file a lawsuit. So they might say, we have a defense based on statute of limitations. There are a lot of things that they could say in response that gives you a window into what their initial response to a lawsuit would be, so that you can either proactively address those in your complaint and allege facts that that undermine those defenses, or you can do additional pre-suit investigation. You can shore up your IP to identify and eliminate any problems potentially that they've called out. So this is a real, I think, undersold value of sending a cease and desist letter. So we talked about now the sending a cease and desist letter clearly can have some advantages. What are the disadvantages? The most obvious disadvantage associated with a cease and desist letter is that it can trigger a declaratory judgment action where the other side sues you first. We'll talk in a little bit about where lawsuits can be filed, but obviously having home field advantage in a lawsuit is beneficial and important. It brings down costs on you if you can file a lawsuit that is close to you, versus having to file one where your competitor is. It's more comfortable for you, and if it does go to trial, it's always good to be closer to home. However, if you send in a cease and desist letter that is too aggressive and the opposing party feels very, strong about securing its own home field advantage, they could, instead of responding to the cease and desist letter, file their own court action saying this cease and desist letter put me at risk, and I want the court to declare that what is said in the cease and desist letter is not actually going on. There's not actually an infringement. And if that happens, you lose that home court advantage. If for example, you're here in North Carolina and you have a competitor infringing your patent or violating your trademark in California, and you send them the letter, you may lose the opportunity to file the lawsuit against them in North Carolina, and may have to end up pursuing a lawsuit if you're not able to work it out outside of court in California. And obviously, that's less convenient. Now, a cease and desist letter can be written in a way to minimize that risk, but it's a risk that needs to be accounted for when you are drafting a cease and desist letter if you decide to send one. The last two disadvantages are similar. Sometimes in IP litigation in particular, and really I think in trade secret cases very frequently, in trademark cases occasionally, and in patent cases occasionally, it's very important. You discover there's an IP problem and you want to go to court right away. You want to get a TRO, you want to get a preliminary injunction where the court immediately stops the bad conduct while the lawsuit progresses. And if that's the goal, if that's deemed appropriate and necessary, sending a cease and desist letter is probably not the right move. It's probably best to go straight to a lawsuit because, again, sending that cease and desist letter, even if you put a short fuse on a response, 2, 3 days, is sometimes all the competitor needs to move around evidence, to create problems for you that'll make it more difficult to prove your claim. And oftentimes, when courts are assessing a TRO or even a preliminary injunction request, they look at how quickly you came to court. And while they want to encourage you to negotiate with the other side prior to filing litigation, if you take too long kind of going back and forth on a cease and desist letter, that in and of itself can sometimes be the basis for the court denying that immediate uh, preliminary relief in terms of shutting down infringing activity. So there are very good reasons to send a cease and desist letter, and there are very good reasons to think hard before you do. So the best practice is always to consult with counsel before sending a cease and desist letter, um, because the strategy matters as much as the language, and the language matters too, particularly when you're talking about the issue of a potential declaratory judgment issue. And so you want to make sure you consider all of these things and what makes the most sense given the specific type of IP infringement you're dealing with, and given the risk that, for example, the opposing party may be able to beat you to the courthouse and secure home field advantage for that lawsuit. Okay, so that's kind of, I think, the initial decision that most businesses face. The first initial big strategic decision most companies face when they're confronted with an IP issue, enforcement issue. And so now we're going to move on to litigation. And so if you send the cease and desist and it didn't work, or you decided to go straight to litigation, the next big strategic question, I think, is where you file your complaint. And there are really two issues that should be considered when you're considering where to file the complaint. The first is whether you file in state or federal court, and the second is where you file geographically. So the state versus federal court decision uh, is depending on the type of IP that you're dealing with. Sometimes that decision is made for you, and sometimes you have options. So in a patent case, if that's the type of infringement you are dealing with, you are always going to file in federal court. The federal court has what is called exclusive jurisdiction to hear patent cases. It is the only system in which patent cases can be heard. And so your option is federal court, state court is not an option. And it really is a good thing, because patent cases, probably more so than any other civil litigation, you like to have a court that's familiar with dealing with the nuances and particularities of that kind of litigation. So you'd probably want to be in federal court anyways, but you don't really have a choice. With trademark, you do. There is, of course, trademarks can be federally registered, but they do not have to be federally registered. And there are federal statutes that provide for relief for both federally registered trademarks and for trademarks that aren't federally registered. And so as long as you have that federal statute and that federal statutory claim, you can sue in federal court if you would like. But it's not exclusive jurisdiction. So state courts are certainly places where you could file a trademark infringement claim, even one that contains a claim under federal law. Now, of course, a defendant, when confronted with such a claim, could move it to federal court, but state court is an option. However, I would say, just generally, if I'm thinking strategically, I would prefer trademark cases would to be brought if the trademark is the centerpiece of your claim. I think federal court is usually preferable, again, because I'd say probably 90% of heavy trademark cases are filed in federal court in the first place or end up there. And so a federal court is going to have a lot more specialized experience dealing with the federal statutes in particular. And those, more often than not, are the ones that are the best source of relief for you. and provide the most guidance for the courts. So I think you'll have an option in state court, although the defendant usually is going to have a basis to remove it anyways to federal court. So my typical advice in that situation, and again, everything is fact dependent, but I usually like to file a trademark case in federal court. Trade secrets are similar to trademark infringement claims, except it's kind of the reverse. For a long time, uh, there have been state statutes or state common law that has allowed for a trade secret claim, and generally speaking, for historically, those have been the primary uh, remedies, state statutes for a trade secret claim. There is a federal statute now, the Defend Trade Secrets Act, that provides federal protection and federal relief for some trade secret violations. And that federal statute, if it's applicable to your case, will automatically allow you to file in federal court if you want. And then there are other situations where even if you are not invoking the federal statute, if there is what is called diversity jurisdiction, meaning that the parties are both located in different states and the amount in controversy is over $75,000, you could file initially a trade secret claim in federal court too, even without invoking the federal statute. However, I think my preference here is like I mentioned, the reverse of a trademark case. I like, particularly in North Carolina, where we have the business court. It's a court that has where, frankly, most of the trademark cases that get filed in North Carolina get filtered to the specialized court, the business court, and all of the judges on that court have a ton of experience uh, dealing with trade secret cases. And so the results are predictable there. There's expertise there, and you know what you're going to get. So I like state court, generally speaking, uh, particularly in North Carolina for trade secret claims. The next question is okay. You've decided state versus federal. Where geographically do you file? Now, in patent cases, you have limited geographic options. And this is because of a relatively recent Supreme Court case that tried to put the kibosh on form shopping or geography shopping when it came to patent cases. There are particular federal courts, a lot of them located in Texas, that are known to be very patent plaintiff friendly. And prior to the Supreme Court case, you could pretty much sue a patent defendant anywhere where infringement was taking place. But the Supreme Court looked at the special venue rules that apply to patent infringement cases and very much narrowed that. So you are now limited in filing a patent infringement case. It has to be in a location where uh, the defendant has a physical presence, meaning like an office or something, usually, or where they are formally incorporated. So for a company like Apple, for example, there are going to be, more options because there is an Apple store in malls. They have employees located somewhere. So you have some options with a company like that. But with a lot of entities, you may only have uh, one choice. If they are both incorporated in a state and have their only physical location in that state. And candidly, that makes it more expensive and more difficult for plaintiffs to enforce their patents. I've had clients that deal with kind of serial infringement of their patents, and people all over the country trying to infringe their patents. And we used to be able to sue them all in our home court. Now we have to go play an away game every time we want to sue one of these smaller entities. So that is a limitation, and I think that there was good reason for the Supreme Court doing what they did. But in all candor, it has made it more difficult and more expensive for a lot of plaintiffs to enforce their patent rights, and you really don't have a whole lot of choices in a lot of cases as to where you can file geographically. Trademark is different. Trademark is far more flexible, and it's generally speaking, you can file as long as they're all the requirements are met. You can file anywhere where infringement is occurring, and if they are if an entity is soliciting customers in your state, if an entity is sending the products with the infringing mark into your state, um, those generally speaking will allow you to sue that defendant and play a home game essentially in your trademark infringement lawsuit. It's not always the case, but more often than not, um, you know, uh, plaintiffs are able to file trademark infringement cases, where they live. And and so that's an advantage, and you can certainly secure that home field advantage, which again is something very important to consider, going back to the last slide when we're talking about a cease and desist letter and avoiding the potential for a declaratory judgment. Trade secrets, those geographic limitations and decisions are again very similar um, to the trademark uh, framework. You will look to see where the misappropriation occurred. And generally speaking, misappropriation of trade secrets, I think, occurs on a smaller scale. And it's generally more localized. So you will have maybe fewer options than you would in a trademark case in terms of where to file. But again, more often than not, I think a misappropriation is going to occur if it occurs pretty close to home. So, in my experience, most people end up, filing their trade secret cases relatively close to home, although that's not always uh, the case. But there are no like special requirements for a trade secret case, uh, like there are for a patent case. So those are, I think, the big considerations in terms of where you file your complaint. And that is, I think, the second big strategic decision that you need to talk through if the cease and desist letter is not the route that's taken, or if it is the route that's taken and doesn't work. And making those decisions and making them quickly and making the right decisions, sets you up for success and hopefully gets you in a position where you can minimize and avoid the costs that I mentioned in the introduction, and that I think Peyton is going to speak about briefly now before getting into the specific types of litigation.
Thank you, Joe. And thank you all for joining us. As Haley and Joe mentioned, my name is Peyton Fuller. I'm an attorney at Ward & Smith and part of our commercial litigation group. And the entirety of my practice I have spent working with Joe on different IP litigation cases. We've been really lucky to have some great clients and have a lot of fun working on those together. So As Joe mentioned, I'm going to talk a little bit, kind of transition us into wrapping up sort of the cost of litigation, which is a key piece of something to consider when we're talking about strategy and considering how, the best way to consider enforcing your intellectual property rights in a situation where somebody needs reminding of your rights. And also, kind of on the flip side, if somebody is trying to enforce their rights against you, some of the cost piece can apply to that as well and help you decide, what makes sense for your business activities and otherwise. So, as Joe mentioned at the outset, we kind of divided this up between the different types of IP as well, but patent litigation cases are not inexpensive. We know that. We've seen that to be true. We looked at a study from the American Intellectual Property Law Association. They do an economic study every few years, and the most recent one that we looked at is from 2015. So it's obviously several years old, this one. But that study shows that, cost of litigation as it relates to patent infringement ties a little bit to, the amount in controversy or the risk associated with the case. And that sort of feeds into what I'll talk about next, which is, how many claims you're going to be challenging that in a patent that correlates with sort of the amount that's being fought over. So when we're talking about a case where we're fighting over $1 million or less, in 2015, the costs were, somewhere between 400 grand to 600 grand to see that through to trial. Of course, that's a 2015 number. So adjust for inflation, as we have been doing in recent years. But I think adjusting that figure up a little bit just based on, costs of today's world and what that looks like is Joe and I found that to be true in the things we've been working on recently. And then of course, if the, amount at risk goes up, so say we're talking about 1 million to 10 million being fought over in a patent infringement suit, the cost went up to 950,000, just under $1 million through discovery, and then just over 2 million through trial. Again, another 2015 number. So, think about adjusting that. And then I mentioned here separate costs for an in tandem IPR proceeding. An IPR proceeding is an inter partes review. Those are proceedings where you are challenging the validity of a patent. So you're basically saying, hey, this patent should never have been granted in the first place. We want to wipe it completely out. A lot of times those are important strategy consideration when we're talking about a patent infringement case, whether you are pursuing, enforcing your patent against someone else, or somebody is trying to enforce their patent against your company or you. An IPR proceeding is a good way to raise the stakes, because what's happening there is that then it would be decided whether the patent remains valid and enforceable at all. So could lose the patent altogether if successful in that proceeding. Those proceedings are also expensive, and they're separate proceedings apart from a pending lawsuit. And oftentimes, we either file or defend those in tandem with a civil action. And so it's a separate set of costs and fees kind of on top of those estimates. A hallmark of an IPR proceeding is there are pretty significant filing fees, depending on the complexity of the patent and how many claims you're seeking to invalidate or fight over in order to have the patent declared invalid. Okay, and then costs for trademark and trade secrets cases. This depends a little bit on the forum. So that analysis that Joe just went through of, are we in state court? Are we in federal court? The kind of typical trope that you'll hear is that federal court can be more expensive than state court. And we find that to be true sometimes, but it really depends on the facts of the case. And with these types of cases, with the trademark and trade secrets case, we're talking about very factual, specific matters. And so if we have great facts, if the facts are really in our favor, then there's a little bit less work to do, and you may not need as many experts or as depth of analysis from your expert witnesses. And in those situations, that obviously helps keep the cost down. If our facts are a little milky or we need to develop them further, then that can cause things to get a little more expensive. It can oftentimes mean that we need additional experts to opine on specific issues to cover a factual hurdle that we need to jump, or the analysis of the experts may have to be more in depth than it would if we had some facts that were kind of home run pieces of information for our case. In the trademark and trade secret space, you also see a lot of times there's a need for immediate, quick relief. And we call that injunctive relief in the litigation space. And so that means, like the most classic example in the trade secrets case is you have a departing employee who swipes a bunch of stuff off the system and goes to a competitor company or goes and starts their own competing business. And the things that they swipe off the system are obviously trade secrets. And so in those situations, time is certainly of the essence. You want to act fast. You don't want to give the opportunity for that employee to utilize your trade secrets and spread them around and make it so that they're no longer protected. And so oftentimes we're running to the court very quickly in those situations, and to get the court involved fast and effectively through an injunctive relief process, whether it be a temporary restraining order or a preliminary injunction. That's a heavy lift out of the gate. You're basically conducting almost like a mini trial before the case has really even begun and you've gotten into discovery phase and other traditional parts of litigation. So in the event that you have a trademark or trade secret case where we've got to push for injunctive relief, you can expect the cost to be a little bit higher just because you're going to have to go through that kind of immediate heavy lift process. Now, the flip side is if you're successful in that immediate heavy lift process, you've done a lot of the work for yourself for the case. And so it can be pretty expensive up front, but it makes it so that as time goes on, things are a little bit more efficient throughout the lifespan of the actual lawsuit that gets filed. Overall, the most recent estimates that Joe and I have found in publications we trust, and also just based on our experience of litigating these cases in recent years, we say anywhere from 400,000 to 2.4 million to litigate a trademark or trade secret case all the way through to trial. And I know that's a really broad estimate. And so what I'll say about that is what you'll hear me say again on some of the next slides as well, in talking about what we need, from a factual and evidentiary standpoint to develop those cases. It just depends on the facts. And so, if we have great facts, then, sometimes we can be a little bit more efficient if we have to develop those facts, or new facts come to light that are not as great for us, then, it can cause the cost to go up and what have you to continue pursuing it. A question that we always get when we're talking about the cost of litigation is whether the fees are recoverable, whether your attorney's fees can be paid by the other party in the event that you're successful. Generally speaking, the federal statutes for patent cases and for trademark cases have a mechanism where you can recover attorney's fees, but that mechanism requires the case to be what's known as exceptional. And so winning your case, even in those situations, it's not enough to make it exceptional. It's a higher bar that you have to prove to the court that, the other side drove up the costs unnecessarily in some way, things like that. So recovery of attorney's fees is not guaranteed, but it is a possibility in some contexts. We generally try to advise clients, and I think the smartest way to go about it from just a business management, financial management perspective, and any company that's gone through litigation can tell you, it's best to consider it a sunk cost, and then on the back end, if it's something that you can recover, then that's obviously a great thing. And one of the things that we really, really do and try to do effectively in these cases is, make sure that the economics make sense. It's a business decision to enforce your intellectual property rights in any either pre-litigation or litigation setting. And so a key part of that business decision obviously is the cost. And so making sure that the juice is worth the squeeze is really important before you just march off to the courthouse and file a lawsuit. And so it takes having, thoughtful conversations and honest conversations, at the outset about what the case looks like and what the process looks like to make sure that you're embarking on something that will ultimately be the right business decision. So, okay, let's talk a little bit now. I'm going to change gears a little bit now and talk about sort of how these different cases are built, a little bit from sort of a factual standpoint, if you will, and a evidentiary development standpoint. So starting off first, we're looking at trademark infringement cases. In a trademark case, the main question that we're going to be asking relates to confusion between your mark and another mark, or the marks at issue in the case. And so if you go back and look at the webinar done by our law partners, Gavin and Taylor Pulliam, they talked a little bit about kind of, how trademarks come to be. And oh, you know what? Actually, I'm wrong about that. Erica gave our summer school IP webinar on trademark cases. So go look at Erica Rogers' webinar on kind of the background of trademarks. But in that, she does talk a lot about, the genesis for why trademark protection is important, and why our courts allow for it and enforce it. And one of the main justifications is consumer confusion. And so naturally, of course, the question that the court is going to be asking when we're seeking to enforce a trademark is, was anybody confused? Is anybody mistaking the products for one another? And so in the context of answering that question, of course, we'll apply different tests, and they'll look at fact-specific things. So they'll want to know whether the products with the marks are sold in the same place, are they in the same part of the store? Are they in the same store? Do they have a similar website domain? Is it off by just a few letters? Is there a slight difference between where you can purchase these products online? They'll look at things like whether the marketing is similar, and they'll look at the look and the feel of the products, and of the marks themselves. They'll consider whether the products and the marks are in the same space. Are they in the same industry, if you will? Are we talking about two marks that are both in like the coffee industry? And how similar are they? And then, of course, on the consumer confusion piece, that is a huge piece. And so they want to know, has there been any actual confusion? Are consumers actually purchasing, something based on a mark that they believe to be the other mark? They'll want to know likelihood of confusion. Would an average consumer kind of fall for and not be able to differentiate between the two marks? Some of the different types of evidence that we see and that can be great for building up a case when it comes to consumer confusion is, direct interactions with customers in some way, shape, or form, where they demonstrate their confusion to your brand, and say, oh, I bought this because I thought it was you and returned it, or, whatever. So that can be really hard to generate that type of evidence. But it's very useful when it happens. And so One of the key things when we're talking about building up a trademark infringement case, which is highly fact specific, is digging into all different facets of the business and seeing whether there's been that type of interaction or there's been factual evidence to support the potential confusion. Sometimes people, consumers or customers are reaching out to the social media team. There's a lot of responding to, Instagram DMs or what have you. Other times they're emailing customer service or calling customer service and things like that. So, depending on the size of your business, it can be helpful to keep your finger on the pulse for those different areas of kind of customer touch points when we're worried about some type of trademark infringement. Because ultimately we gotta know whether there was confusion or if there's likelihood of confusion between the marks. Some strong evidence that we see in this space: consumer surveys, sales data showing harm, and again, like I said, the golden best option we can have are examples where there's been actual consumer confusion and that's been communicated to the business. Okay, so next we're going to talk about kind of a patent infringement case and how we work to build those cases out. When we're talking about a patent infringement case, these are very, very technical lawsuits. The outcome of an infringement case is going to turn on what the claims in the patent mean, and whether the accused product or process actually meets those claims. So if we're talking about enforcing, so you have a patent, we have to look at what your patent says, the claims, and then we have to compare that, and this process all happens with the court, of course. The court will compare, what the patent says to the actual accused product to determine if it infringes. In a patent infringement case, we go through a process known as the claim construction process. Sometimes it's called a Markman hearing, and it happens early in the case, and it is a very intensive and important piece of any patent infringement lawsuit, because that is the piece of the litigation where the court decides what the patent says. So when we know what the court decides the patent says, then we know, okay, are we going to be able to demonstrate that the accused product does what the patent says it covers? And so that piece of the litigation involves a lot of technical work, expert testimony, and so we do a lot of collaboration, with different experts depending on the subject matter of the patent itself and what area, what type of industry that patent covers. And so we also collaborate a good bit with, in those situations, a lot of times with the attorney that prosecuted the patent or that obtained the patent. So like if you've watched our previous webinars, our patent prosecutor at Ward & Smith is Ryan Simmons, and he gave the Patent 101 webinar a few weeks ago. And so we'll collaborate with the attorney that drafted the actual patent, and we'll go through, what the process looked like with the USPTO when the patent itself was obtained, what the USPTO, what the patent office had to say about the patent and its claims and all of that at the time that it granted the patent. So you go through kind of that very technical process that again is always going to involve typically always going to involve some type of expert testimony and in consideration of how we should be reading the patent. And then, one of the key things about once we've filed a patent infringement lawsuit, we also want to typically seek to obtain a litigation hold in order to have evidence preserved about, how they are developing the accused product and things of that nature, facts related to the accused product itself, how it's made, how it's supposed to operate, etc. because all of those things will help us determine whether the product reads on or matches with the claims of the patent that we're trying to enforce. Okay, and then last but certainly not least, for a trade secret case. So I mentioned before, trade secrets, the most common example that we see of these is, the departing employee, who sends them, emails their personal email account with, all of the company's recipes and other trade secrets, on, 2 days before they turn in their notice or something. And you would think that people would have enough sense to not do that, but they do not. We see it time and again. Employees think that they're going to abscond with company material. Now I will say sometimes they're creative in the way that they attempt to abscond with trade secrets, but we do see it time and again. So I'll reference that example in the course of kind of talking through this slide, but in a trade secret case, oftentimes when you have that absconding employee or, a competitor who's gotten their hands on your company's trade secrets, we need to move fast. And that speed is going to be critical because it's like the toothpaste getting out of the tube. It's hard to get back in once it gets out. And so we want to put the cap right back on that toothpaste as quickly as we can, just for practical reasons, for oftentimes business, practicality reasons of, we don't want your competitors getting their hands on something. We don't want a competitor bringing something to market that is going to undermine, your brand or your product. And so, in those situations, we are frequently seeking injunctive relief, like I talked about before, whether it be a temporary restraining order or a preliminary injunction, in order to be successful in obtaining injunctive relief. Like I said, it's I like to call it's almost like a mini trial at the very beginning of the case, which makes it kind of rare. Typically, a case goes on for a long period of time. You do discovery and all the other things, mediation, etc., to develop a case, and then you have the trial at the very end. When we're talking about obtaining, injunctive relief, we are going to be before the court very quickly. We've handled matters where we had to get emergency relief and we got it within 48 hours of being retained. It's a very quick process and it can be a very heavy lift at the outset. But we're obviously fortunate to have a judicial system that allows businesses to, go and get that protection immediately if needed. And so in those situations when we're dealing with a injunctive relief process at the outset, you have to prove your case at the very beginning, and so you want to have all your ducks in a row, as quickly as you can when it comes to kind of factually developing your case before we, show up to the court and ask for injunctive relief. The things that the court's going to ask in an injunctive relief setting are listed here, but it's likelihood of success. So how successful will you be on the ultimate claims in the lawsuit? Irreparable harm. So how bad is it that your employee has run off with these trade secrets? What kind of harm will that have to the business? And is that harm something that can be cured through, payment or other means of, remedies that the court can provide? A balancing of the equities. So, what's fair. And then of course the public interest is the public or the consumer is going to be harmed by this? And if so, how? And so in order to answer those questions, it's really important to have, like I said, our ducks in a row before we race to the courthouse. So keys to success, you want to have documentation of your trade secrets existence and protection measures before somebody runs off with it. And so this is what Gavin and Taylor talked about a little bit in their webinar previously, but some of the things you can do are make your trade secret protections part of the employment and hiring process. Okay, so have your employees, when you hire them, sign documents as part of their employment agreement that says they're going to protect the company's trade secrets, and they understand, that they have a continuing obligation to protect those trade secrets, even if they depart from the company, things like that. And then you want to ensure that you have processes in place to, protect and reinforce the secrecy, of the trade secrets themselves. So, you know, um, limit the number of people who can access the trade secrets, have them password protected with legitimate passwords that are not, written down and taped on a bulletin board next to the company's computer in the main office, keep track of who is accessing them and when and how and for what purpose, things like that. Um, you know, it can be really beneficial, when we're talking about a trade secret case to, um, consider all of this on the front end, which, you don't need to consider this until it's too late to have considered it a lot of times. And so it's important to, make sure you've got good counsel, advising you when you're setting up, okay, what does our hiring process look like? What does our employee termination process look like? Or, how do we handle monitoring, employees when they are departing? Do we have a system in place with our IT folks to, call and go through their email once we've learned that they're no longer going to be working with the company, but before they've left? Things of that nature. Do we have a system in place for their departure where we're reminding them of their obligation, not to abscond with our company's trade secrets? And development of those things on the front end makes it so that if you have to go to the court, and seek emergency relief, we've got the factual, heavy hitters. We've got those home run facts, that we can put before the court confidently and obtain, protection and relief successfully. So, okay, I know we're a little bit over time, and I think we're wrapping up here. Thank you, Haley. Yeah, so, key takeaways from this, I feel like Joe and I've said this till we're blue in the face, but obviously IP enforcement is a strategic business decision. It's not just legal reflex. It's important to build it into the strategy of how you run your business, how you operate your business, from the ground up. And so thinking about that, on the front end, especially if you have intellectual property that's, really key to your industry or your market advantage. Just considering that from the ground up, I think is huge. Speed matters. So, right, like we just talked about trade secret cases. Once that toothpaste is out of the tube, it can be hard to get it back in. So we want to keep the cap on the toothpaste tube. Knowing our forum options. Are we in federal court? Are we, one thing we didn't really talk about, but can apply in some instances is, alternative dispute resolution. So are we in a situation where we're going to be, arbitrating some of these issues, before an arbitration panel? We need to know, where are we going to be having this fight, if it's a fight that we're going to have? And then, of course, the best strategy begins from the ground up before any IP protection need arises. So, you don't need to do all this until you need to do all this. And so it's good to think about it on the front end. You guys have already done that, first step by joining us for this series and learning more about it. So, hopefully we've given you some things to think about and some good questions to ask yourself and, us if you ever need our help with any of these, disputes. And, yeah, if you guys have any questions, I think Haley will take, questions from the group now.
Hey, great job, guys. Such interesting information. We don't have too much time for questions, because we're a little bit over and I want to make sure we're respectful of everyone's time. But please, email Joe and Peyton if you didn't catch their email addresses, at the beginning. It's on there on our website. And we are so thankful you guys joined us today. This, like I said, this is the last webinar. This is actually my last webinar of the summer, and this is the last webinar in our IP Summer School series. So some of you may have graduated. Congratulations. Um, like I said, there will be a recording and slides coming to you probably tomorrow morning with all of this information. And that is going to conclude today's webinar. Thank you guys and have a great rest of your summer.
Thank you, everyone. Thank you,
So
Haley.
much.